5 seconds to go. Start. The relief which the plaintiffs sought was not for the continuation of the right of worship, but a declaration of the status of the structure being a mosque. The learned judge held that the pleadings did not bring the case under Article 142, since the plea in paragraph 23 of the plaint was not sufficient to constitute a case of dispossession or discontinuance of the possession of the plaintiffs over the property in dispute. The placement of idols inside the mosque, it was held, did not constitute a dispossession or discontinuance of possession, since these concepts contemplate a total deprivation of the person who was earlier in possession. Obstruction or interference, it was held, does not constitute dispossession or discontinuance of possession. Justice Sudhir Agarwal noted that if the plaintiffs had not set up the plea either that they were dispossessed or that their possession was discontinued in categorical and clear terms, the court could not provide the deficiency by reading something which was not present in the pleadings. Justice Sudhir Agarwal held that for the above reasons, neither Article 47 nor Article 142 had any application. Dealing with the case under Article 120, the learned judge noted that the cause of action arose on 23rd December 1949 and 29th December 1949. The suit was instituted beyond the period of limitation of 6 years. Hence, whether the last namaz was held on 16th or 23rd December 1949 would be of no consequence. The date on which the last namaz was held would have been of some significance if Article 120 was not to apply. In the absence of the application of Articles 142 and 144, it was only Article 120 which would be attracted, and the suit was held to be barred by limitation. On whether there was a continuing wrong, Justice Sudhir Agarwal held that if the suit had been instituted for seeking relief against the obstruction of the right of worship, it would probably have attracted the principle of continuing wrong in Section 23 of the Limitation Act 1908, particularly in view of the decision of the Privy Council in Sir Seth Hukum Chand versus Maharaj Bahadur Singh. However, the suit had not been instituted to seek an enforcement of the right of worship, but for obtaining a declaration of status about the nature of the building in dispute as a mosque, and for delivery of possession in the capacity of possessory title holders. Justice Sudhir Agarwal held that a distinction has to be made between a continuing wrong and continuing effects of a wrong. The facts pleaded by the plaintiffs indicated that they were ousted from the disputed premises on 22nd and 23rd December 1949, and the wrong was complete once they had been dispossessed from the property. On this ground, the learned judge held that the principle of continuing wrong was not attracted. Justice Sudhir Agarwal held that the ouster of the plaintiffs was complete with the desecration of the mosque on 23rd December 1949, and hence the suit for the purpose of limitation was governed by Article 120. The suit was held to be barred by limitation. Justice D.V. Sharma held that the suit had been instituted for seeking a declaration after the attachment by the magistrate under section 145. The suit seeking a declaration was not governed by the principle of a continuing wrong, and in view of the decision of the Privy Council in Raja Rajgan Maharaja Jagatjeet Singh versus Raja Pratap Bahadur Singh, it was Article 120 that would apply. Stop.